Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Principal and Founder of Carolyn Lee PLLC, Carolyn Lee, and we're here to talk about investment immigration. Our firm helps clients build their futures with investment immigration. And who better to have us be here together on a Saturday afternoon, New York time, than Pete Calabrese of CanAm Enterprises. Hello, hello. And Arindam Sengupta of My Global Citizenship. And I am going to make sure we have a little bit of time to do a full and proper introduction of these two incredible gentlemen in the EB-5 space that I'm just so proud and honored to call friends. So the format is going to be this. We're going to be talking about some really important and hot topics in lawful source of funds, some alternative types of source of funds, and some questions about timing that have arisen. And we're going to do that by covering some principles, some underlying concepts that really help us answer the questions. Can we do this? Is this lawful? Is this valid? Should this be acceptable? Because truly the permutations in terms of the kinds of source of funds that we're going to be working with, case by case, investor to investor, there's going to be a lot of variance there. So the idea is that with these principles, we'll be able to kind of tackle these variances with these underlying principles of law and USCIS EB-5 guidance in mind. All right, cool.
Thank you, Carolyn.
We're talking about essentially source of fund strategies that are so on the minds of investors who are in H-1B right now. Many of you for many years, too many years, thinking about going to EB-5 and really an alternative green card strategy, right? This is what we're talking about. From the extremely backlogged EB2, EB3 categories. So, and in this connection, we're going to be talking about, well, there are the traditional source of fund strategies that we've all been talking about since time immemorial. You've got your earned income, your sale of an asset or house, you're mortgaging that asset, you're selling stock. All of those are still very, very much in play. But what about some of these other kinds of source of funds that haven't gotten a lot of play traditionally, that we're kind of talking about more as we think about, well, can we pull these down? Can we pull these other assets and sources and loans, put them together so that we can reach that investment threshold of 800,000 plus the admin fees? All right. Disclaimer. This presentation is not advice, it's informational only, and no part of this is legal advice, and there's no attorney-client relationship created without a signed engagement between Carolyn Lee PLLC and the client. The content is promotional and should be considered attorney advertising, and any timeframes that we talk about are going to be estimates, and they vary widely. And I'll also throw in, we're not going to be talking about anything case specific, but we'll be keeping our discussion at a general informational level, okay? A little bit about myself. I've just been very fortunate with my friends as well as in the course of my career in EB-5. It's been very, very good to me. I've served as 6-term chair, co-chair, and vice chair of the American Immigration Lawyers National EB-5 Committee. And in that capacity, I've had the opportunity to study EB-5 law, comment on EB-5 law. And that really culminated in my service as legislative counsel to Invest in USA, or IIUSA, where the dream team drafted, worked together to get the EB-5 Reform and Integrity Act of 2022 passed at last in March of 2022. I currently also serve as co-chair of IIUSA's Public Policy Committee, where we continue to comment and talk about emerging USCIS policies. On the private side, in my capacity as counsel, I've represented U.S. project clients across our great nation in rural, high unemployment area projects, representing over 2.5 billion in EB-5 capital alone. And on the investor side, I've represented and advised and handled thousands of investor cases from the start of their EB-5 journey through to 829 approval. So what a privilege. About Arindam Sengupta. He is the founder of My Global Citizenship. And I'm just going to run these incredibly impressive credentials through, and I'm going to kind of yield to Sengupta, to Arindam, to talk a little bit about himself in his own words. So Arindam, of course, is the founder of My Global Citizenship. He's had over 15 years experience in asset management across CBOT, Reliance Mutual Fund, and Citadel corporations. He's an alum of Indiana University and Princeton, where he obtained his graduate degree. He's the founder of EduFund, a company that's affiliated with Mass Mutual. MGC was established in 2019, a very good year, and has assisted over 125 families in obtaining their second residency or passport. And about 70% of these families have opted to start a new life in the US through the EB-5 program. And the leadership team at MGC is registered with USCIS in accordance with RIA requirements under subparagraph K. So, Arindam, in your words.
Thank you, Carolyn. So, well, as you guys see, I spent considerable amount of time in the US. I've spent that time as an F1 and also as an H1 when things were very different. I think I was blessed. I lived in US where American immigration was much less complex. So I can relate to a lot of this complexity that a lot of H-1B people and especially F1 are going through today. And the motivation for this webinar, I think it came from one of my colleagues, DJ. A lot of you may be talking to him or may have interacted with him. So DJ leads sales at MGC, and what we realized was something very fascinating. We've done about 85 cases of EB-5 roughly, half in the pre-RIA and half post-RIA. And what we've seen for us as a company, post-RIA, we are seeing a lot of H-1B people file. And their source of fund is completely different than what we are used to seeing from India. So for us as a company, the SOFs that we are seeing now is 180 degrees to what we've seen in the past. And that got us thinking, can we have a webinar to address just SOF strategies for H-1B people? Because those are very typical. You won't have other people with similar SOF strategies. And yeah, so that's a little bit about myself and our motivation for doing this webinar.
Awesome.
Thank you, Carolyn.
Thank you, Arindam. All right. Peter Calabrese is the CEO of CanAm Investor Services. CanAm, of course, needs no introduction, but it was founded in 1987 and has worked exclusively in the EB-5 program for over 20 years. Its EB-5 industry-leading track record of success includes $2.27 billion of repayments to investors. As for Pete himself, prior to joining CanAm in 2015, he worked for 15 years in institutional sales and trading, focusing on equity, derivatives, and volatility products. Pete earned a bachelor's degree from Brown University with a concentration in business economics and holds the FINRA Series 7, 24, 63, and 66 licenses. And he's just a good guy. Pete, take it away.
Thank you. Wow. Thank you so much. And thank you so much for having me. I mean, anytime we get to interact with you and your, track record and your experience is really just, unprecedented. So we really appreciate this. And obviously, thank you for the kind words. So CanAm, we've been working in immigration-linked business investments for, at this point, over 35 years. Our founder, still president and CEO, Tom Rosenfeld, started the company back then, still very actively involved in the firm. And I've been blessed to be able to work here for over 9 years at this point. But our COO, Christine Chen, who you know very well, Carolyn, has been with the firm for over 20 years. Talked to the members of my team here at CanAm Investor Services. We've been here for close to 8-9 years as well. So, when you talk to our group and when you look at, I guess, the experience I've had previously in my career is, we worked on a lot of complex products, a lot of complex financial products, but really we've worked in big team environments and understanding that the most important thing is the relationship that you are fostering with this group that you're talking to, this individual that you're talking to. Because, when we talk and, what Tom will always say to us, whenever we look at an actual project, we would say, I wouldn't put these investors into a project I wouldn't put my own mother. Tom is himself an immigrant who came here from this country and holds dear to that principle, which is why when you look at the way CanAm does things, we take a best in class and we take really a best practices approach to every step along the way. And that's what leads to the group that I run, CanAm Investor Services. We are a FINRA SEC registered broker dealer. So that not only are we complying from a parent company standpoint with all of the immigration aspects of this and having all of our own in-house departments to handle all the different aspects of it, but we have this FINRA registered broker dealer so we can be compliantly conducting this sale of a security. Because even though EB-5 is a very unique security, it is still a security and it has many different compliance aspects that go along with it. So that was definitely a big motivation for us in having this conversation as well, because as the RIA has come on in and brought so much fantastic change to the EB-5 program, one of the real core things that has really revolutionized the program is the ability to concurrently file an adjustment of status along with their investment, which it's not like having H-1B investors or F1, but any of those types of US-based investors is wholly new for us. We've had this has been a pathway that people have taken for years, but this ability to concurrently file has really brought so much more attention to the program and really opened up the eyes of it to so many of these H-1B types, which has just become a huge focus for us, not just because these are great people that we love to have as ultimate clients of ours, but because as a registered broker dealer, we know how important it is to be doing things compliantly, talking to these US-based individuals and making sure that they are making a qualified securities decision as well. So thank you so much. Thank you so much for this platform, this opportunity to talk with you guys, because really, I'll say this personally to everyone. This is one of the largest investments that you're ever going to make, ever, and it is certainly the most personal investment that you're ever going to make. So, the amount of time and effort and due diligence that goes into this is not lost on myself or my team when we're talking. So we're talking to individual people with very individual needs, and we try to make sure that we are very cognizant of all of those. And so this platform is very much appreciated to be able to talk about all that.
Thank you so much, Pete. Thank you so much. Let's kind of jump into this, and then I'm going to close our PowerPoint presentation and just kind of let everyone see our faces as we speak. We're going to be talking about, to kick off our conversation, what are the underlying principles for building the lawful source of funds? And when we understand these principles, that apply no matter what type of source of funds we're talking about, no matter when, these principles are going to apply. So the idea is to share these principles and help them kind of illuminate the questions that we're going to have on a case-by-case basis. Okay, so I'm going to stop share. What are we talking about when we're talking about these more emerging types of source of funds? We're talking about these questions of what types of source of funds qualify, at what level of investment, right? What we're lucky enough to have, gobs and gobs to draw from, maybe less of an issue. But when we're talking about, putting together different sources, the question of, well, do I have to put it all in at once up to 900,000 almost, or can I put it in over time? The question of partial investments and when the entire amount has to be fully in, these questions come up. And then finally, timing. It's related to the notion of partial investments, right? On the one hand, how long will I have before I need to have it all in? And also the question of sustainment of the investment. Once the investment is in, how long does that have to remain in the investment in the new commercial enterprise? So we're going to try to cover as efficiently as we can principles that kind of undergird these questions. And I want to start with the concept of capital. This is really the seed that animates this entire conversation and all of these questions. And it's important for us to know these words that define what capital is. Investment is your investors' contribution of capital into the new commercial enterprise. That is how investment is defined in our space. So we got to start with capital. What does it mean? And I'm going to read from the RIA, the statute, okay? Because it's all about words when we're trying to figure out whether we're within these words or not. The term capital means cash and all real, personal, or mixed tangible assets owned and controlled by the alien investor. Critical. Owned and controlled. It's going to answer a lot of questions. Or held in trust for the benefit of the alien, to which the alien has unrestricted access. This is going to answer a lot of questions today. Shall be valued at fair market value in the United States. And then I'm going to stop because we've hit the germane aspects of the definition of capital. And when we look at that definition, we're going to see that the governing principles are you've got to own, control, have unrestricted access. So if you have some right in it, but it's not wholly yours yet, it's not vested in you yet, then it's not capital. You have to own it, have control over it, unrestricted access. It's not sufficient for you to just have some beneficiary interest in it. So I think that's going to help us answer some of these questions about the types of capital: RSUs, ESOs, HELOC, SDIRAs. Level of capital investment, okay? It is clear to me that we can be in the process of investing. That's the language in the statute, in the process of investing. That means that an investor doesn't have to have the entire required amount of capital in at time one. Which leads naturally to the question of, well, by when does the entire required amount have to be in? My interpretation is that the entire amount does not have to be in until the end of 2 years in conditional residency. And that's based on my reading of the Reform and Integrity Act, including Section 216A, which governs conditions removal. Okay, so that's quite a time span. However, this is important. Based on my interpretation of the statute and the regulations, the entire amount has to be committed at the time of the 526E filing. And we're not going to talk about the various permutations of facts that might establish commitment, but that is a requirement. You may not have to have the full 800 plus the admin fee at time one at the time of 526E filing, but you have to show that all of that is committed, in my view. And then thereafter, you've got until the 2 years in conditional residency to fully fund. We're going to talk more about this. I'm just going to kind of tease it a little bit in terms of the sustainment, okay? There's a lot of conversation now in our community about how long the investment has to be sustained in the new commercial enterprise. And I think it must be said that it is also in flux because it's also the subject of litigation, wholly aside from it being brand new policy as well, which is always going to have some inherent uncertainties associated with novelty. So we're gonna hit some of that a little bit later on as well. So those are the principles. I think that's enough for now, and we'll tease them out as we go. Well, let's get into some questions, specific applications of these principles, okay? So let's start with a question. Can I invest with a partial investment? So you're asked this question all the time, Pete and Arindam. How do you answer this?
I say that it is okay, right? I usually say that, look, you have to be in the process of investing, but like essentially I stole your line, but yeah, but that's what I say. And I think it works out well because what I understand from most of the people I talk to, while a lot of people have 800,000 committed, they don't have liquidity for 800,000 ready, right? So, and timeline is such a crucial thing for EB-5. I encourage them that you are very much in your bounds to file with a little bit and get started.
Okay.
I agree. I mean, you touched on in your very eloquent opening, Carolyn, that this is lawful, and that is always the interpretation that we're going to. And we don't like to dabble in the maybe sort of, because when we look at this, you'll see from us, we're conservative almost to a fault, but we are always going to be looking to take the most conservative pathway. And so to your basic question, I would say absolutely yes. I mean, it is lawful for someone to file while while with a partial, because for whatever reason, whether they need that much longer to go ahead, maybe they have a very specific priority date that they need to have established while they are finishing theirs. So that is absolutely lawful. I mean, what I would say, and what maybe we might touch on a little bit more here as well, is that we also need to make sure that when you're talking about it, and say maybe if you're talking to a regional center, that lawful and provided are potentially different things, because there is what's lawful and what is allowable within the EB-5 program, which we are always going to provide, well, which we're always going to stand by. But there is also the commercial terms of, say, a specific project, or maybe say of a specific regional center, as to whether or not that's allowable for them. So I think that's something that's very important, is making sure that you're differentiating between saying this is lawful, this is a lawful way to do it, and a regional center could very much, like, there are things that are lawful that we say, but we also don't, because we don't necessarily, maybe we don't feel comfortable with it, or maybe the group that we're working with is not able to provide that, because, like, say for us, like, for the ability to partially remit to a project is really incumbent upon the group that we're working with, because we are a third-party regional center. We are providing funds on the behalf of this borrower.
Yeah, so what you're saying is it kind of, you got to check in with your borrower to make sure that a partial funding at time 3 is okay.
100%, absolutely. And that's where that flexibility would come from for us, because it is lawful and we do want to be able to provide that, but there are some restrictions. And I guess maybe that's the difference of, say, working with, say, a third-party regional center like ourselves versus maybe, say, like a vertically integrated developer. They could provide more flexibility, but there are other things such as conflict of interest that come into play there. But these are commercial terms that are lawful, but it does come down to the specific processes of maybe that regional center or that specific project maybe that they're working on, at least in our case.
Yep. Okay. Arindam, before we turn to SDIRAs, ESOs, RSUs, do you have anything you want to add to that on the question of partial investments?
Correct. I wanted to ask a question that I get asked a lot on partial investment. There is this notion that if I do a partial investment, I'm almost signing up for an RFE, which essentially then means a further delay, right? Because while you get a, time frame to reply, that's a delay, right? So if you could please throw some light on it.
Sure. Well, I think that it's kind of, this is the point that I think Pete is making about how much risk you're willing to absorb and how much you want to take off the table. And in the context of partial investments, put it all in if you can, right? That removes that risk of the partial. But if you're putting in partial, how can we minimize the risk? I think minimizing the risk is providing as robust documentation as possible of the committed nature of the remainder. And part of that showing of commitment is a plan and a time frame that you don't want to not abide by. So it's got to be realistic because you don't want to have to defend it being off rails. But at the same time is also a time frame that looks and feels and sounds good. Again, realistic and achievable, but looks and feels and sounds good. And so, I think, shall we leave it at those principles, or, I think we can kind of start maybe talking about on an individual case by case, well, concretely, what are some of the specific timeframes? And, we can have a kind of an open discussion about that in terms of whether, you and Pete have certain timeframes for completing the funding that you prefer or have seen or been asked about.
Peter, I'll let him go first. Please, Peter, over to you.
Yeah, we certainly get asked. And Carolyn, to your point, you're basically describing our processes. We are open to it. We are comfortable with people completing their doing a partial. They would have to document when their actual schedule is going to be, when their completion is going to be, so we can send that and have that schedule in place for the investor to abide to. But really, for us, it's going to come down to the flexibility that's in place for the borrower. And like you said, in general, and then really in general, most of our investors will fully fund their investment. But that's also not to say that this isn't an important aspect, and this flexibility isn't important to a large number of investors, especially the ones that we're talking here today. So, generally what we will do is when we will start with a project, we will, talk to our borrower to kind of see how much flexibility that they have. Into our conversations with our investors and let them know we will have some flexibility for a partial funding, but it's going to be limited. And just like there's a limited number of spaces in the project in general, and once we do hit that maximum number of spaces, we do have to alert people, and we do have to be fair and just very transparent in that availability. The same aspect goes with the ability to fund and in an extended time. So we will put that in place, and once we reach our maximum number of individuals who are able to use that, we're very open with people about that. And it's for us, we want to be flexible, we want to be fair, we're always going to be lawful, but we need to make sure that we are just being very transparent in the things that we are comfortable with, the interpretation that we're comfortable with using and putting forward for people, but that there are certain limitations because we are a third party.
Yeah, third party, right? Makes sense.
Makes sense.
All right, let's hit the next one. So a lot of folks want to hear what we want to say about these types of funds: SDIRAs, ESOs, RSUs, HELOCs. Let's kick this off with, what are some of the common questions that you get from prospective investors in H-1B about these types of source of funds?
So I can go first. What we've been getting, right, as a company is it allowed to use SDIRA? Can I use my wife's SDIRA? And the third question is, look, these are kind of different SOFs. They have not been used a lot in the past. Is there any track record of approval? Because everybody, that's the thing that everybody is working towards, right? Approval of the petition. So they also want to know is, has there been a track record? Because that's the ultimate.
Yeah,
So
yeah.
these are a couple of questions that our team gets asked a lot.
Pete, how about you?
Yeah, I mean, very similar question that we get asked. And, you know, again, these are things that we want to be able to provide flexibility where we can. Okay, for instance, you know, we do have a platform to allow for investing through an SDIRA. You know, so you would be setting up an account with that group. We make sure that we have our offering available on that platform of theirs, and then that's a pathway for funding for sometimes generally a partial amount of the investment amount, but you know, oftentimes a significant amount of the investment amount could be coming from that. So we make that platform available. In terms of say RSUs or HELOCs, we hear that as funding methods all the time. That's not necessarily something that is that we would need to facilitate, and it's something that we would, and really we say this with every instance, is make sure you're talking about this with your immigration attorney. Make sure that you're, you know, that all of this is kosher before you start going forward and executing any of these things, especially.
Yeah.
But also, even just before you start to move funds around on this, make sure you're talking to someone. I mean, similarly with the SDIRA, we do provide for it, but all of this should be part of a plan that you're formulating with your immigration attorney. You know, and then what we're talking about now is what would come next is the actual execution of it. And we do provide that as a platform for the execution. But Carolyn, I mean, because this must be something that you get all the time, because you talked about it before when you said, you know, what about this part? What about this part? You know, you might be looking at this very large collection of funds, but these 3 or 4 sources might be the best, the easiest ones.
Yeah. Let's break that all down. This is like super helpful stuff. So, and we get these questions, right? You know, can we do this? And how does it work? And, you know, it might be my wife's or my spouse's accounts. And it just, there's just a cloud of questions about this, right? Like, how does it all work? And can I do it? And the answer is, let's go back to the principles, right? All right. So what are we talking about? Do you own it? And what is it? Do you control it? And do you have unrestricted access to it? Now, the interesting thing to me about these products we're talking about is that the client has an interest in various aspects and phases of these assets, right? I think that's what's so confusing. You have cash in your bank account. That's yours. And if that account is in your name, you have control over it. With these other products, it's not quite so clear. Sometimes there are custodians involved. Sometimes there are other parties involved. They seem to have some control. They may be advising. So do I meet the requirements? Wonderful. These are exactly the kinds of questions that one should be asking. So let's just kind of look at an account like this. And let's just look at a retirement account. And it might be an account that has some sort of custodian or someone with a fiduciary obligation over it, which is confusing. Now, this account might be, I'm just going to use myself as an example, maybe hypothetically. I might have this account, but is this capital? Well, do I have unrestricted access to this right now? No, I don't. It's not the same as having $900,000 in cash. Let's come back to that as a concrete benchmark. Why? Because there might be some conditions that I have to fulfill before accessing that, before it can become cash. So that's the way that we want to analyze this. I have some interest in this account or product or asset, but I have to sign things. I have to fulfill certain conditions of employment. I have to meet other milestones and check boxes before I own completely and have full and unrestricted access and control. No one else can tell me what I can do with this. That's when you know that you have control and unrestricted access. If it's at any other point, if your employer has some say, if some custodian or Schwab or some institution has some say in that asset, and you can't access it and use it in any way you like, then that is not capital. You have some interest in it, very important, and you may be able to liquidate that interest. But at that moment in time, in that state, it is not capital. Okay, so then the questions are, all right, now I know, thank you. I know it's not, I have some interest in this and I may be able to work with it, but it ain't capital yet. So then it's about, how do I get it from that state to the capital state? That's the question. And then that's about, you've got to figure out, what are the conditions? What do you have to do with your employer? What do you have to do with the institution? What do you have to do with the custodian to get that asset into a form where you own it 100%, unrestricted access and control? And that's going to vary. Once it is in that state, then it's capital. Then you can contribute it to the new commercial enterprise. And you've made an investment. It could be partial, but you've made an investment at that point.
Makes sense.
Great explanation.
That's very helpful.
And I think you're spot on, Carolyn, because this is the conversation that this is the planning that needs to go in before you actually go ahead with the execution, right? And those are the two different steps. And I talked a little bit about the execution, but then I guess to take a step forward for someone who has now had this conversation and gotten this fantastic description from you of their source of funds, and when is this actually capital? And then maybe they start talking to Arindam, and then they start talking to me, and they say, well, this is what the situation is currently. This is where we have to try to be and try to help them, is to gauge them with what's the actual time that they can actually go ahead and make an investment. Because for some of these people, all of this planning that you're talking about, this can take time. And someone might come to us, and we get all the time to come and say, nope, I'm good. My source of funds is great. And I would say, maybe talk to someone like Carolyn for a little bit first, because it's a very complicated process I'm going through. So this process that they might be looking at, it might be 3 months down the line. It might be 6 months down the line that they're actually able to go ahead and make an investment. But this is where you need to start looking into some of these different aspects and saying, maybe there is a project where, for whom, like, you've talked to your immigration attorney, and we can source all of it now, but half of the funds won't be ready for 3 months. Well, then maybe you could then talk to a regional center like someone like us and say, is the ability to execute that a possibility? To fund, say, half of the investment now and then complete it in 2 to 3 months, in which case we would now come back and say to them, yes, we have that, we still have that level of flexibility with our borrower for us to be able to do that. Or no, unfortunately not, but it sounds like your ability to make a full investment is 3 months down the line from now. We have this on the horizon that we can talk about with you, which is a project of ours that will now better suit your timeline for completing the investment. And that's,
in fact,
we try to walk.
If I could add a point here, I think in majority of the client cases that we worked together, I think there has always been that flexibility and that window of 3 to 4 months. I mean, we've always had that, which helps people plan it more effectively.
Mm-hmm.
Yeah.
let's talk about loans, shall we? Loans in the source of funds, which has been the subject of tremendous confusion on everybody's part, including the agency, as we know. Okay, so let's talk about loans. This is so interesting to me because, yes, I'm an EB-5 geek, evidently. And it's, you do have to kind of be disciplined in analyzing this because it is confusing. So let's start with a little bit of the basics, and then we can kind of talk about HELOCs and, loans and unsecured loans and secured loans and stuff like that. So, I think what's kind of confusing about this is that sometimes it's permitted and sometimes it's not, and both are loans. When is it permitted and when is it not? It is not permitted if you, the investor, are making a loan to the new commercial enterprise. You cannot do that. You cannot give the new commercial enterprise money and then have that new commercial enterprise owe you. Okay, so you cannot be the lender. You, the investor, cannot be the lender vis-a-vis the new commercial enterprise. Okay, no. However, I think this is what has been at the heart of what's been confusing to the agency. You, the investor, can owe the new commercial enterprise. The new commercial enterprise cannot owe you. The new commercial enterprise cannot be your borrower. However, you could be the borrower to the new commercial enterprise. You can give the new commercial enterprise a note that says, I owe you. I could give the new commercial enterprise cash, and I could give the new commercial enterprise the rest of it in a promissory note. And I have completed, it's not a partial investment, it's a full investment. Okay? So that's what's a part of what's confusing about this. Now, historically, what's also been confusing is this notion of indebtedness that USCIS, in legal error, said was the prohibited situation. It's not. This situation of indebtedness was and is one where in the source of funds, you, the investor, had a loan somewhere. Sometimes it was often, most of the time, it was a mortgage. So there was an asset somewhere securing that loan. Sometimes that asset was wholly owned by you. Other times it wasn't. It was maybe your grandmother or your parent, or you and a parent and a grandmother. Service said this is impermissible indebtedness because there was a loan in your source of funds, and it got confused with the situation where the new commercial enterprise was your borrower. That wasn't the case. You did not take a note from the new commercial enterprise. You didn't even give the note to the new commercial enterprise. You gave cash. But the service saw a loan somewhere up there and said, oh, this is that prohibited situation. And it got reversed. So the right result is now in place. But it is this history and the inherent confusion that has kind of fueled a lot of the fog and the questions about loans that are permitted. That's all by way of backdrop. So let's, some of the specific questions you get, and I'm going to maybe turn it back over to you, Arindam and Pete, for these questions that you get from the prospective investors, because you guys are on the front line. So yeah, hit us with it. What are some of the questions that you're seeing and getting?
See, for loans, one question that I see is that now a lot of RCs or new commercial enterprises have started giving loans, right? And this is a very new thing, at least I was not aware of it. And this is a question we have all the time, that is it even legal? Will I even get approved? Because everything again comes back to approval. So I remember distinctly, I was having dinner with a prospect in Charlotte, and he definitely needed a loan. But he was very hesitant to take one because there was this overhang of loan not being kosher, and eventually the approval being at stake.
Yeah.
Yeah.
Cool. Love that. All right.
Yeah, no, I mean, we get that question all the time, is can we get a loan? And look, so much of the source of funds or the actual funding for these investments that people are going to end up completing are going to be coming from loans. But that also doesn't mean that this also, at least from our standpoint, it falls into one of those buckets of, is this legal? Is this lawful? Yes. Is this a service that we provide? No, we don't. Because we just, it's not something that we feel comfortable with, of giving a loan to an investor. You know, we feel comfortable that they are going to work with their immigration attorney, that they will be going ahead with a lawful pathway for taking on loans and the funds that they're ultimately going to be completing it with. It's a layer of complication that we feel uncomfortable engaging with a client on. It's, you know, we want to be able to provide flexibility where we can. We want to be able to provide platforms for, you know, potential alternative funding mechanisms like we talked about, like an SDIRA. But that's a spot where we prefer not to be engaged with the client in that manner. We want to give them a good, strong investment option to get them their full immigration, to get them to retain their funds. That's a step that it feels a little uncomfortable for us.
Well, I mean, I think this to me like goes to, you know, this really, each case, right, gentlemen, it's like it's your thumbprint, it's your fingerprint. Every single case is individual, it is unique. And everyone on that team is going to have levels of comfort and what works and what doesn't. And so it truly is, I mean, that's one of the fun things about this, is that the art of it, case by case, is that it is truly uniquely your case as investor, how it looks. And I think, you know, what he's speaking to is exactly that. And that, you know, the project component is also that, a part of that wonderful variance. Arindam, did you have something to add to this before we kind of like maybe talk a little bit more specifically about loans?
No, I'm good. I mean, please go ahead.
Okay, and then
we'll
take questions. We'll take questions. So, I mean, I think I've actually said all I need to say about loans, which is there's one situation you cannot have. And that is where the new commercial enterprise owes you. The new commercial enterprise cannot be your borrower ever. And as long as the new commercial enterprise is not your borrower, it is not a prohibited loan. It may have other issues, right? Not saying that, but it is not the one transaction that we know is off the table, does not work. Okay, everything else is open for discussion, and it may not be something that, as a matter of prudence or as a matter of other options one goes to, depending on the investor, but it's important to know what is actually prohibited. Let's open the floor up to some Q&A, shall we? And again, I want to encourage folks to write in if you have any questions following this webinar. When you see the video, contact us at contact@Carolyn Lee PLLC, and we will make sure the question is answered. And I want to actually, before taking a couple of questions, just also pop open contact information. for our incredible panelists. Okay. So questions. Should we take a couple? All right.
Carolyn, I think we had a question previously or on the lead up, talking to a little bit about how long do my funds need to be at risk. I think we had touched upon that a little bit earlier, and that is one that is it's a not necessarily a complicated answer, but it is another one of those questions that falls into the bucket of what is the legal sustainment period, or what was the lawful time frame for which your funds need to be at risk, which every regional center or every project should be complying to. But then there is also the commercial aspects of the project, right? I mean, you could, there is the time frame that you need to make your funds. For us, we're looking to make sure, we talk about this, often. Now we're looking to reach the full immigration status of our investors, and we're looking to get them to repay their funds. And so the time period of, say, your investment will go towards both of those. We need to make sure that we have enough of a time frame to meet the lawful term that you need to have the funds at risk. But then we also want to make sure that the project is, the term is long enough that you have an opportunity for this project to reach stability and to be able to actually repay the funds, because that is a very important part of it as well. Now that is a commercial term. I mean, I'm not saying this, but if you talk to a project and they said the term of this project is 10 years, then if that's what you sign up for, you are going into an investment, you are going into an obligation that you're making with it. That if the project says that, then that's what you're signing up for. Right. I mean, so for us, we want to make sure that we have that we'll structure our projects, because this is a question that we get a lot of. Hey, why isn't your project only X amount of years long, 2 years long? Or how about, can I just get my funds back as soon as I hit what I think I've reached as my sustainment period? And, the answer to both, well, the answer to the latter is, well, because the project has a term and you're committed to the term. And the answer to the former is, we want to make sure that we have plenty of leeway for you to reach that sustainment period from an immigration standpoint. But we also want to make sure that this project has a sufficient chance to reach its stability and get your funds repaid and to be successful. So, if you wanted to, if that's something that you'd like to opine on and as well.
Yep.
Sorry, I lost you.
And what are you hearing, or what are some investor questions about the sustainment?
I mean, look, I think at least a lot of people that I have spoken to, I mean, I hear all types of notions that how long is the sustainment period, right? When does it actually kick in? And till when is it actually valid, right?
Mm-hmm.
So these are the two main things.
Yeah, well, I mean, I think let's, start with what we know. So it must be said that this is an area that is in flux, like I think I said from the very beginning. And so I think we all in our space need to be careful. The statute is, and I'll read the language, okay? And this is new from the RIA. We're talking about employment creation visas, EB-5 visas, right? And we're talking about the amount of the investment, this is the new language, which is expected to remain invested for not less than 2 years, not less than 2 years. So it means it can be more than 2 years. It can't be less than 2 years. And so this is the language that has spawned the October 11, 2023 USCIS guidance and the subsequent conversations and now litigation.
Because I think, Caroline, I think that will be fair to say is it's not necessarily a question of how long necessarily the sustainment period might be, or at least the way oftentimes I'll explain it. It's more of a question of when does that sustainment period actually begin? And I think that's a question that comes to us. And you know, we try to explain to someone that you might have start making your capital contribution at a certain point. Well, that doesn't necessarily mean investment is sustainable.
This is a fantastic segue, and then I think we'll leave it at that, which is this is where everything kind of intersects that we've been talking about. Based on USCIS's non-statutory guidance that's published, the time that it's the 2 years, it has to be from the time that full investment is made. So if there's a partial investment, that doesn't start the clock. And based on this guidance, which isn't statute, but it's guidance, the funds have to also be down all the way to the JCE level. So it's not sufficient if it's in an escrow account or even at the NCE account level. And there has to be full completed job creation. So it certainly isn't the case that, you know, that anything goes in terms of a 2-year time frame.
Absolutely.
Again, I caution folks, we have to be very careful here, especially investors.
Absolutely. I couldn't agree more. Yeah, I mean, there's a lot of steps that go into the beginning of that sustainment period, which is why, you know, we are very careful in the structuring of our projects from a long-term standpoint for both that immigration and investment reasons.
We're gonna leave it at that. There are a couple of questions about specific project kind of type questions, like return provisions, meaning like the rate and, you know, sort of the financially kind of questions. This is where investor due diligence along those dimensions, as well as immigration, you know, it's an important undertaking in one's life. And so this is a part, you know, these are a part of the questions that you as investor will want to ask as you vet through your options, okay, before undertaking this incredible journey. I mean, congratulations to all of you. I want to close by saying every one of us here welcomes you. You know, you are exactly the kind of person this program is about. You are investing yourself in the United States. You are making an at-risk investment of your precious hard-earned funds into an enterprise in the US that is going to create jobs and create positive economic benefit. So thank you. And we are all very pleased to support.
Thanks a lot.
Thank
you, Carolyn, for hosting this. Thank you. Thanks a lot.
My
Thanks.
pleasure.
Caroline.
Good being with
Peter.
everybody.
Thanks a lot.
Be well.
Thank you. Bye.
Bye-bye.
Bye-bye.